We are very pleased to be here today to talk about the extraordinary situation that's facing all of us with the coronavirus and the impact it's had on the workplace. The workplace not only in the United States, but the workplace around the world, including, of course, Japan. And while every employer is affected by this, regardless of where they're located, we recognize that, of course, there are different legal issues in different jurisdictions. There are different cultural issues to think about. And so we're going to try to look at this from, certainly at the very least, the US perspective and the Japanese perspective. So let me just say that we do have three terrific presenters today. I'm going to be acting as moderator. I'm going to be asking a lot of questions. We also, of course, are very happy to take questions from you if you have any. I know that a few folks have already submitted questions, so we're going to try to refer to those as we get going. I want to mention that, we don't have a PowerPoint today. For those of you who've come to watch a PowerPoint, I hope it's not terribly disappointing. If you do want, we have lots of PowerPoints on these topics. If you want to send an email to the Japan Society registration number, we'll be happy to get a PowerPoint to you. You can also, I'd refer you to our website. The firm, again, is called Littler, Littler. And if you go to littler.com/coronavirus, we have a ton of information. It's continually updated. A great deal of resources for employers that you might find useful. Of course, don't all get on it at once because you'll crash our website. But anyway, happy to help. So just very briefly, we have. I want to introduce you to our three speakers. Devjani Mishra is a colleague of mine, a shareholder in the firm Littler. She has extraordinary experience in advising companies in employment and labor law. Devjani also worked for a time for a biopharma company, so has worked in-house, and a great deal of legal knowledge and practical experience. She is a whiz at the coronavirus information. So we're going to be starting with Devjani. We're then going to turn to my colleague, Melissa Peters. Melissa is an expert in OSHA-related matters, in occupational safety and health matters. She will be covering some of the return to work issues that surround this whole problem. And finally, we're very, very happy to have with us our friend Hiro Tsukamoto. And Hiro is a lawyer with the law firm Nagashima Ohno Tsunematsu. Hiro is located in Nagashima Ohno's New York office, and he will be providing us with the Japanese perspective on these issues. So, Devjani, I'd like to turn to you to start. And by the way, just again, what we're going to be talking about today is legal developments and employer response to COVID-19, furloughs, layoffs, the WARN Act, new laws on leave and time off, and then we're going to be talking about returning to work, the issues surrounding return to work. So Devjani, tell us please, what were employers' initial responses to this crisis? Talk to us about furloughs, layoffs, and so forth.
Certainly. So for most U.S. employers, this is basically somewhere between the third and the fourth month of their response. We have, had a few months where many employers have been under stay-at-home orders, which at one point encompassed 42 states in the U.S., as well as the District of Columbia and Puerto Rico. And so at the outset of this, there were some businesses that were anticipating this sort of stay-at-home order based on what we had seen from countries in Asia and in Europe that were ahead of us in the coronavirus timeline. So some companies had started sending more people home to work remotely. Other companies, based on the nature of their business, we're looking at the prospect of actually shutting down because it's the type of work that cannot be done remotely. It can only be done in place. And so, you know, at the outset of this, we had companies trying to figure out how to have people go home. We also had companies deciding how to temporarily pause their businesses. And so the ones that temporarily paused their businesses, many retail companies, airlines, hospitality industry, many of them looked at different measures to either temporarily or perhaps medium to long term make reductions in their workforce in order to save expense. So you mentioned furloughs and layoffs and then terminations. Furloughs, typically that is a temporary reduction in the hours of work or the days of the week that people will be working in order to cut payroll expense. It's something that's very often used in businesses that are cyclical. When a project ends, people are put on furlough. In this case, you had companies furloughing large portions of their workforce with the expectation and the hope that they would be able to recall people to work quickly. Layoffs are similar to furloughs. They tend to be a little bit. Sure.
No, I was going to ask you, I'm sorry. So we're using the word furlough. I just want to spend a minute on this. You know, is a furlough, is there a legal definition of furlough? Is there one kind of furlough, or is this something that we've all kind of been, you know, making up as we've gone along to some degree? Is there one way of doing a furlough? What can you tell us about that?
Sure. So furlough is not something that has a very well-defined legal meaning. It has typically been used in unionized workforces, but what we saw was that companies were taking a variety of different steps and calling them all furloughs. So in some cases, people were suspending everything, suspending pay, suspending benefits, sending people home. In other cases, we had companies that continued benefits while people were on furlough. In yet other cases, people were allowed to use their paid time off. So furloughs are not something that are very well defined. I think we've learned more about furloughs in the last 2 to 3 months in the US than we previously had known. Layoffs and terminations, on the other hand, are pretty well defined in the US, and that typically is a, you know, semi-permanent or permanent loss of employment, where you are ending the employment relationship, you are paying out everything that's owed to the employee, benefits, and you know, here in the US, unlike many other countries, health benefits are usually tied to employment, so termination actually cuts benefits, and furlough may or may not do that.
Okay, and so I think, and just for one more second, so the notion of furlough as being something, it's that I think essentially companies were looking to as a way to maybe try to, you know, we don't know what's going to happen short term, we don't know what's going to happen in the medium term. We'd like to maybe keep people as a member of our family, if you will. Maybe we'll be able to continue your benefits. Here's what we're going to be doing short term. You're not going to be paid any longer. You can apply for unemployment. You'll get, maybe we'll provide you with benefits, and let's see how long this lasts, right?
Right, that's right. And furloughs are a bit unusual because I know many of our audience will be familiar with the idea that in the US, you know, you're employed at will and you don't usually have a promise of continued employment. But for the people on furlough, you know, usually when you furlough an employee, you are sending a message to that employee about expecting to recall them at some time in the future. Whereas if you lay someone off or terminate them, it's typically, we have no expectations. We don't, you know, think we'll be recalling you. So we had many employers who were hoping that this would be short-term, limited in time, and so they were using furloughs as a measure to temporarily pause things with the hope that maybe in 4 weeks or 8 weeks, we would be back to some kind of normal and could recall people.
Okay. And we're going to talk a little bit about the WARN Act in a few minutes, and I think that this whole idea of furloughs is important on that subject. But before we get to the WARN Act, let's talk a little bit more about, you know, what happens with terminations. You know, when when we're, or even laying people off, are there, what issues does the employer have to think about when there's a layoff? I mean, for example, might there be severance pay? Might there be vacation pay?
There absolutely could, and I think for many of the members of our audience, you may have a pre-existing severance plan, or you may have employment contracts with certain high-level people that if you end the employment relationship, you have to pay out compensation. You usually have to convert people's health insurance under our COBRA law, and then the employee has to continue it at their own expense, if that's what they want to do. There may be other kinds of payouts depending on your incentive systems. So, you know, that is normally a very serious, permanent change in the relationship, and it requires a different sort of legal analysis. But I think at least at the outset, most people were not doing terminations. Contrast that to now, this situation has gone on for a period of time. Different businesses are feeling the effects differently, and some companies that may have furloughed employees to begin with are finding they may not be able to recall them, and they will have to take the next step and actually terminate and take those consequences in terms of payouts and severance, if there is severance.
I mean, I know that one thing we've been recommending is a lot of companies may have severance plans embedded in their employee handbooks or other policies, but the idea of these severance plans normally is to provide severance for somebody who's terminated without cause. But it probably wasn't developed in anticipation of a crisis like this, where they'd have to potentially pay severance to their entire workforce. And so one thing we're advising our clients to do is to look at their plans and policies and consider, frankly, amending them to make clear that perhaps they don't want to provide severance in this kind of unusual circumstance where essentially they're terminating everybody or laying off everybody temporarily, just to clarify that. So Devjani, let's talk about the WARN Act, if we can turn to the WARN Act. And obviously it's a highly complex statute, and we don't expect a real detailed, you know, there's a lot of detail to it, but what can you tell us about how it interacts with the issues we're facing today?
Sure. So the WARN Act basically is the one sort of major federal statute that if, you know, in the US, if you are terminating enough employees, requires you to give 60 days advance notice of that termination. And in a situation like this, where we have a global pandemic, you know, there are certain circumstances where you can claim that unforeseeable business circumstances kept you from being able to give that kind of advance notice. This is, you know, many people would say this should be the clearest paradigm example of unforeseeable circumstances, you know, difficult to predict the effects on the business. And certainly government orders shutting down your business would be unforeseeable. The consequences, if you do not follow the WARN Act, involve having to give that period of pay and benefits to each employee. So it's very important to look at the federal statute, and also in certain states, including New York, New Jersey, California, there are what are called mini WARN Acts. It's important to check those to determine whether you have satisfied the definition of unforeseeable circumstances, or whether you will have to go back and provide the equivalent of that notice period to employees that you're terminating.
So and by the way, I'm not sure if you're aware, have there been any guidances issued on, you know, for example, from the federal government? I mean, is this an unforeseeable circumstance, or is that not yet settled?
There have been some guidances on the state level. So in California and New Jersey, the governors in those states issued some guidance, and the New Jersey legislature clarified. But on the whole, there has been less guidance, perhaps, than we might have expected. So some of this, you know, will really come down to probably individual cases that the Department of Labor either brings or does not bring, for us to know, you know, for sure whether the definition of unforeseeable circumstances is met. And to be clear, there will probably be a difference between people who conducted layoffs just as these orders were coming out or conducted furloughs at that time, versus people who maybe have held on to their workforce throughout and are only beginning that analysis now. Because the argument would be that the longer you wait, the less unforeseeable it would be.
Okay, and there have been class actions brought in a number of states against employers in the past who have failed to comply with WARN. And so while the damages are only 60 days notice or 60 days pay for individuals, if you've got hundreds of employees who've been negatively affected by that, it creates an incentive for lawyers to bring these kinds of claims because they get their attorney's fees. And so complying with WARN is a significant issue. Can you just, to wrap it up, can you talk to us a bit about furloughs and, aggregating under the WARN Act? What is that whole concept and the risk with furloughs in particular, perhaps?
Sure. Many of our clients in doing the furloughs had to consider whether to send the WARN notice at that time, and many of them did actually send that WARN notice at that time because WARN does not just look at how many people you terminate at once, but there are look-back periods. Again, these vary depending on whether you're talking about national WARN or the mini WARNs in different states, but you really need to go through a sophisticated analysis to determine how many people have fallen out of your workforce or will have fallen out of your workforce as a total percentage and whether you have triggered it. Furloughed employees that never get recalled may turn into terminations, and that will affect your exposure under WARN.
And isn't also the case that the WARN Act doesn't apply unless the termination period goes over 6 months? So that if you anticipate this may only be a 3 or 4 month layoff, but if it turns out it goes over 6 months, then you've got a WARN Act problem, which argues in favor of giving this, so we call it a soft WARN notice, right, Devjani?
Sure. I think the key thing that we all acknowledge throughout this situation is it's difficult to predict. It's already gone longer than we would have expected. Our recommendation, if you didn't initially provide WARN notice and you are not yet in a position to recall employees, it makes sense to do the WARN notice now and at least set yourself up, set the clock ticking so that you can minimize the exposure.
Okay, there are so many issues, and I may come back to you, Devjani. I'm going to try to come back to you for some issues in terms of paid sick leave and these various laws that have been passed to deal with the federal laws in particular that have been, and state laws dealing with sick leave and requiring employers to give time off to individuals who even fear they might have been exposed. But before we go to those issues, let's turn to Melissa. So Melissa, talk to us a little bit. Let's dive right into OSHA and workplace safety. What are the key obligations?
All right. So in the situation that we're in, there really aren't any directly applicable OSHA regulations that apply outside of, I would say, the healthcare industry. So right now, what we are operating under is what is understood and known as the General Duty Clause that was created by the OSHA Act. And that requires an employer to provide a safe and healthy work environment for its employees. And of course here, the potential hazard that we have is exposure to COVID-19, the coronavirus. So employers are charged with doing what they can to abate this hazard of exposure. Given that it's a known risk, they're aware of it, they have a duty to protect their employees against the exposure. So that's basically what we're operating under here, given the relative silence from the regulatory agencies, of which I mean OSHA, federal OSHA and state OSHA plans during this time.
So Melissa, you and I have worked on a few matters, and I'm sure you've worked on hundreds of matters since this whole thing started. You and I have had the opportunity to work on a couple together. And the ones that I can recall in particular deal with, for example, when somebody has been exposed, where we know that one of the company's employees, and we're talking, I guess, a company that's still permitted to remain open, right? So we work with a number of companies that are still permitted to be open, that are called essential employers, providing essential services like banks, similar. So you've got somebody who's in the hospital. So they were holding meetings one week, and the next week they're in the hospital with the coronavirus. So you've got that situation where somebody has gone out sick, and you know they've had the coronavirus, and they may have been in meetings with people. And then you've got the situation of potentially cleaning the workplace and so forth. Can you just give us a breakdown of some of those issues, some practical examples of things you've dealt with?
Yeah, sure. I mean, the key with I guess what you would say is the remediation measures that need to be employed in the event that an employer learns that one of their employees has tested positive is to the best of the employer's ability, ascertain who has been in close contact with that infected employee, and then to also disinfect the workplace. There are also, situations that arise where a common question we're getting that's complicated, primarily because the CDC has not offered any guidance on it, is what to do when an employee presents at work with symptoms of COVID-19, but for whatever reason, they have not been tested. They haven't been able to be tested, or a doctor thinks that they're not sick enough to give them a test. What do we do, right? What we're advising employers to do in that situation is to keep the symptomatic employee out for the 2-week period, the incubation period, just to ensure that they're not potentially infecting other employees. It's difficult for those frontline employers that need to have their employees boots on the ground to perform their work. It's a little bit easier for office type industries where people can perform their work from home. But situations like that are what we're seeing, and it's very complicated because there are no direct answers often, or guidance even, that's provided for us to follow to help advise our clients.
What about issues like, the issues that I keep hearing, the questions I keep getting again and again, and I know most employers have their employees either working from home, if they can work from home, or unfortunately they've been laid off or furloughed. But again, and some of these issues really pertain to, I think, coming back to work perhaps as well. But what about things like face masks? Do employers have to require employees to wear face masks? Are there guidances on that? What about temperature screening? What can you tell us about some of those protective acts that companies should either think about doing or have to do?
Sure. Well, I mean, what we are advising, of course, is that depending upon where you are located, a lot of, our clients have maybe only 1 or 2 locations, other ones are in all 50 states. The first thing to do is to ensure that you are complying with local orders, both state and local orders, because as we know, the guidance is varying greatly from state to state, city to city, county to county. So for instance, I mean, to California and New York, we have a lot of clients in both of those locations, New York City and Los Angeles. Given the dense population in both of those cities, both cities have taken relatively conservative measures towards requiring things like face masks, temperature screening, symptom screening. So the first thing is to become familiar with what's required in the locality. And then the next thing is to do an assessment of your workplace. For instance, in Los Angeles, they're saying if you are in a situation where your workers cannot maintain 6 feet of distance between each other when they're performing their work, they need to be wearing the cloth face coverings. And we understand, of course, that the cloth face covering does not necessarily protect the wearer. It protects the other people that are in close contact with the wearer from being exposed to the respiratory droplets that are expelled from their nose and mouth. Mm-hmm. So, I mean, things like that are incredibly helpful. Mm-hmm. Symptom screening, we're seeing a lot of. I think that is helpful. It's either an employee self-certification, at home prior to coming to work, or questions that are asked upon arrival at work. Of course, the idea is to try to keep sick people from coming to work. So if you can sort of nip it in the bud and identify those symptoms or a fever prior to the employee showing up at the work site, that's what's going to be ideal.
Mm-hmm. Well, I'd like to ask you how you're going to do that, but I have a broader question, which is, what do you think will be the key challenges in reopening from a workplace safety standpoint?
Well,
And maybe
I think
you've just identified them.
Well, no. Yeah, I mean, some of what we talked about are elements, I think, that are going to be required in an effective safety program. But I think the difficult part is going to be creating an effective safety program that accounts for and shifts with the changes in local and state orders and CDC guidelines as states move from closing to reopening, and then potentially closing again if we experience a second wave of outbreak. So, I mean, one of the challenges that we've experienced as attorneys counseling during this time has been keeping up with the constant changing guidelines. And we would always recommend that our clients adhere to CDC guidelines. We think they've done a phenomenal job in terms of, advising or providing, I guess, guidelines that are in line with what is currently known from the scientific and medical community regarding the virus. So, I mean, it's going to be difficult for employers. It's going to be an administrative burden, certainly, because a lot of these industries that are now having to think about safety and health have never had to do that before. In the past, it would be high hazard industries like shipping or mining. Of course, safety programs are a part of their day-to-day. But now office environments that are, in a lot of cases exempt from reporting and recording requirements under OSHA because they're low hazard, are now having to take on this administrative burden of creating a plan, implementing it, recording the efforts that are being done. And it takes a lot of time. It takes a lot of manpower to do that if you're not used to doing it.
I don't know if you've mentioned contact tracing yet, but can you just spend a minute telling us what that is and how that might present itself?
Sure.
And who's going to do that?
Sort of glossed over it. Right. So our recommendation is that you identify people at the company, whether it's members of HR or if you are a large company, you have an in-house legal team. Identify people that are sort of your COVID-19 task force. So everybody is on the same page and up to date with all the current protocols that you're implementing. I think it's useful to use like a contact tracing chart. Basically, you identify anybody.
Contact tracing?
Okay, so contact tracing is the action that is done when you have a positive case. So when someone tests positive, you are then required, to the best of your ability, to ascertain which other employees or individuals have been in close contact, as that term is defined by the CDC, with that individual to attempt to control the spread or infection. So you have to identify anyone who has been around the infected individual for longer than 10 minutes in a distance of 6 feet, right? So passing someone in the hallway is not close contact. Having a conversation with them, eating lunch with them where you're sitting across a table that is only 4 feet in diameter certainly is close contact. So the employer then has the burden to go back and try to figure out who the infected employee has been in close contact with. And that's what we're talking about with contact tracing.
So the infected employee is out sick, maybe even in the hospital. How on earth are employers going to be able to do this?
Right. I mean, the ideal situation is when the infected employee, if they're not completely debilitated in the hospital, is able to participate in the contact tracing and can work with the employer and say, hey, I remember I had lunch with Melissa the last day that I was there. So you maybe need to make note of her. Alternately, employers can look at just sort of environmental situations in the office. Like, does the infected individual have an assistant? Do they have a supervisor? Do they have certain team members they usually work with? Go back and look at calendaring. Did this person participate in a group meeting on a certain day? Those are other options or tools that can be used.
And so let's talk just finally about some of the, I mean, obviously our firm has offices all over the country. We have received briefings on the things that we might need to be doing in terms of going into the office itself, getting into elevators, going upstairs, going out for lunch, having visitors. Tell us just briefly what some of the practical issues might be for going back to work.
It's a lot. It's complicated initially because it's going to require a lot of front end work and assessment. But then once things are in place, the good news is I think it'll be relatively easy to maintain. You're going to have to do an environmental assessment. So you'll have to decide, okay, are we using shared elevator banks? How are people going to get to work, right? Is there a parking garage? Are there other situations where they're going to be around, in close contact necessarily, like riding an elevator to get to our office? Then you need to look at the space layout of the physical office or work site itself and do what you can to set it up in such a way that people are not going to be within 6 feet of each other. Now, this is challenging for a lot of reasons, but there are things that can be done if you cannot separate people physically. For instance, you can have a closed door policy, require people to close their office doors.
If they have offices.
If they have offices, if they have cubicle situation, you could also insert plexiglass or some sort of barrier protection between the cubicles if you can't get the employees 6 feet apart, just to literally act as almost like a sneeze guard so people aren't infecting one another. It's difficult because it requires maintenance. It's a combination of installing environmental controls and then ensuring that these policies and practices are followed.
I mean, is it possible that our president will get his wish and in the next 30 to 60 or 90 days, things will just lift and we'll be able to go back to normal? What is your sense of that?
I mean, I don't know. And I'd like to hear Devjani's opinion on this as well. Of course, everybody would like that to happen. I just don't know if it will. And so I think what we need to do is advise our clients to be prepared to have these safety concerns be a part of the workplace reality going forward. So the more sort of preparation and work they can do now in the event, like, let's say, the doctors are saying that the fall is going to be difficult. We may have a resurgence then with the combination of the bad weather and flu season, coronavirus might surge again. So I think people need to be thinking down the road, what needs to be done now to try to get these protocols in place. So in the event they need to be, put back in place quickly, that can be done. So.
Okay, thank you. And Devjani, I'd like you to hold that thought, but I do want to turn to Hiro-san, Tsukamoto sensei. Are you still with us?
Yes, of course.
Okay, good, great. Hiro, thank you for being with us today. So tell us, how are Japanese companies who are doing business in the United States, and maybe there's really no difference between the way Japanese companies and US companies are responding to this, but what is your sense of how your Japanese clients are responding?
Oh, well, of course, it depends on the size of the company or nature of the company. But, because as you pointed out, they are doing business in the United States, although, they are Japanese companies or Japanese companies' US subsidiaries still, or they are acting in the same or similar manner as the US companies are responding to this crisis.
What about the issue of expatriates? How are expatriates affected by this? And tell us a bit about, most of the people in the audience, I presume, will know what expatriates are, but tell us a bit about that. Expatriates will often come here and then go back to Japan, maybe after a while. How is it affecting their lives?
First, many Japanese companies send their business people to their US subsidiaries as an expat. For, let's say, 3 years or a 5 years basis, and then they go home, to Tokyo or Osaka, or any other cities in Japan. And or during this crisis, or in response to this crisis, I think or many expatriates tended to stay in the United States, and instead of temporarily going back to Japan, primarily because I think first, traveling under these circumstances might not be very safe. And second, or if they go back to Japan, they need to, or take the PCR test, and then need to undertake a 14 days self quarantine, or just like US is doing right now. And also, or Japan is not safe very much anymore. So, or because of those reasons, I think they tend to stay in the United States rather than going back to Japan.
So let's talk about how Japanese companies in Japan are responding to the crisis. What are you seeing in terms of general employment practices? Are they implementing layoffs, furloughs? What can you tell us about how things are going there?
Sure. Well, in Japan, first of all, there is no counterpart to the U.S. at-will employment concept. So it is very difficult for Japanese companies operating in Japan to involuntarily terminate its employees. And in order to adjust their workforce, I understand that at least some of the companies operating in Japan started introducing started soliciting voluntary resignation based on the mutual agreement basis. And also, or some of them started refusing renewal of the fixed-term employment contracts, so that they can overall reduce the workforce. And also, or some of them are working, with the unions or employees to figure out how they can, on one hand, reduce the working hours, and by doing so, reduce the salaries.
And so, so there is some negotiation about reductions in pay. Can Japanese companies unilaterally? So one thing we didn't really have a chance to talk about with Devjani, unfortunately, but in the U.S., unfortunately, a lot of our clients have been forced to reduce pay for a number of their employees. It's common knowledge, of course. It's in the newspapers and all the reports. So because we do have employment at will, and there are very few contracts in place, companies generally can say, we're going to reduce your pay by 10%, 20%, 50%, depending perhaps on they can, whatever criteria they like, but maybe depending on your level in the company, whether you're able to continue to work, whether you can work from home or not, what kind of work you're able to do, and so forth, and just what the company's financial means are. Do you have similar flexibility in Japan?
Well, I'm afraid not. Japanese companies operating in Japan do not have the similar flexibility on that point. As a general rule, they need to get a consent from the employees about a pay cut or a wage reduction. Of course, or there are some, or some exceptions, but as a general rule, we need to get a consent from the employees.
Well, so it sounds to me as though this could be a situation where, unfortunately, like in the US, companies may have to go out of business if they can't continue to pay their employees. Has there been any government help for these companies?
Yes, there are several different kinds of, government subsidies, both at national or government level and prefectural or state government level, and and also, or under if the employers operating in Japan satisfy some requirements or prerequisite, then they can get special or subsidies called employment adjustment subsidy from the government.
So there are payments being made both to employers and to employees.
Well, those subsidies are will be paid to the employers, and there are a different type of subsidy or payout to individuals or employees as well.
So what are those? What kinds of measures have the Japanese government put in place for employees directly?
Well, first, Japanese employees, because, well, in Japan, because or many schools were temporarily shut down. Or employees needed to take care of their children at home, and because of that, they need to or take days off, and there are some subsidies for that. And also, or now, or Japanese government is, well, I think started paying out some special subsidy, but the amount of which is relatively small.
Mm-hmm. What about working from home in Japan? Is that an option? Do you see many employees working from home?
Yes, there are at least some employees working from home, but even at the end of the last month, April, the percentage of the companies which already introduced working from home system was relatively small. And according to the statistics, nationwide, on average, there were 27% of the companies which introduced working from home policy. But in the big cities like Tokyo or Osaka, the percentage was much higher, like 50 something or almost 60%.
Let's talk about I just want to spend a moment talking about the cultural difference. I mean, we're all talking here about implementing rules and policies and expecting that people will follow them. Of course, in the US, we just had yesterday or the day before, I think the governor of Texas announced that, the head attorney, I think the Attorney General of Texas announced that if companies were requiring employees to wear face masks or were not permitting, if local governments were issuing orders like requiring employees to people to wear face masks or saying that companies could not open, then they could be prosecuted. And we've seen people in the US doing things like, carrying guns into meetings and protesting the idea of having to stay closed. Do you anticipate similar kind of social unrest if this thing continues in Japan, if employees are not permitted to go back to work?
Well, first of all, no guns in Japan. That is rule number one. And second, with respect to social unrest, I'm not sure, but honestly speaking, I do not expect, or there will be a big, or unrest in Japan, or primarily because of the nature or character of the Japanese people, or in general. So, I think, or once the government issued the guideline, or once the companies issue the guideline, then, or the public of Japan or the employees working in Japan tend to follow their guidance, even if there is no real sanction.
Okay. All right. Thank you, Hiro. Let's turn back to Devjani. And Devjani, I think I do want to turn to the subject of going back to work and what we see the key challenges are or might be. What do you anticipate the key challenges might be for going back to work for employers?
Wow, there's a number. I mean, Melissa covered that really the first place you have to look is, are we actually allowed to be open? And then if we are allowed to be open, have we complied with all of the safety regulations that are required? I think once you get past those two questions, you can begin to think about what does opening look like? And this is going to vary a lot for different employers, but one thing that we have to be very careful with is that after this period of time when businesses have been closed or people have been working remotely, individual employees have suffered some very serious consequences during this time, whether they are medical consequences, personal losses, financial insecurities. And people will justifiably be reluctant to return to work. Some of those people may qualify for accommodation because they fall in a higher risk category for serious complications if they contract coronavirus. And our EEOC, our federal anti-discrimination agency, has articulated some guidance for dealing with those issues. It may be that the employee says, I am at greater risk. It might be that the employee lives with someone who would be at greater risk. Coupled with that, even though businesses may be reopening, the economy may be reopening, our schools are largely not reopening. And of course, here in the US, we run through May or June typically. We expect that summer camps will be affected. We expect that there will be school closing or alterations to schedules into the fall. So many employees do not have anywhere to put their children during the day, and that's going to affect their availability to return to work. And I think the other piece of this, which both Hiro and Melissa alluded to, this is a virus. It's a medical situation. And so we can hope and try to prepare and take the best steps that we can to set up workplaces for people to come back. But realistically, people will continue to get sick. I am not at all a doctor or a biomedical researcher, but I can tell you, and many of our audience members are probably familiar, that the process of developing a test and a treatment and a vaccine, which are all fundamentally, medical and involve trials and testing themselves to make sure they're safe for human use, that is a long process. And so this will be with us for a while. It's important, as Melissa alluded to, that your safety plan is not just comprehensive, but that it's reversible, because whether you have an exposure in your workplace and you need to briefly shut down, or whether we have another wave of this and we have a recurrence of what we've just been through, those are going to all be real challenges for employers.
Well, so here's Devjani, the former biopharma lawyer, speaking. But Devjani, a question we get a lot actually is, what about employer liability? What if, first of all, what if an employee says, I'm scared to come back to work, I don't want to come back to work, or they come back to work and can an employer reasonably worry that somebody might get infected if they come back to work? I mean, what about liability? Should people be asking for releases? What should employers be doing here?
Right. I mean, we do get that question a lot, and people have been asking about releases a lot. An important thing to know about our system is that certain types of claims cannot be released. So an employer's obligation to provide a safe workplace, as Melissa knows very well under the OSHA Act, that's not waivable. An employee's right to bring a whistleblower claim about unsafe practices is generally not waivable. We have in the US the workers' compensation system. And so if an employee is able to show that they contracted coronavirus or another injury or illness at work, that is what that employee's recourse is supposed to be. But having the employee, sign a waiver as a condition of coming back to work not only is not going to have much legal impact, but is probably a deterrent to employees to come back, because it essentially signals, we're not ready for you to come back, but we want you, the employee, to accept the risk of coming back. And many employees will say, as you said, either I can't for some medical reason, I can't for some economic reason, or I'm scared to come back. And interestingly, during this period of time, a number of states and localities have adopted different kinds of sick leave that may well cover the employee who is scared and allow them a window of time not to come back, and at least impose on the employer. And is that the case in New York,
Devjani? Is that the case in New York?
Yes, that is the case under New York City law, and there will be a new category of state leave available. It takes effect in September, but it becomes available in January, where arguably an employee will just be able to say, I am afraid and I'm going to take leave for personal reasons. And also the employer probably has an obligation to dialogue with that employee and figure out whether some other kind of work is reasonable. And because everyone's been working remotely for this period of time, it will be hard to argue that remote work is not a reasonable alternative.
So thank you. We're running low on time. I do want to turn to some questions that we have gotten a couple of questions, and I'd like to ask, and I would ask this, I think, of Hiro and of Devjani, if you can respond. And it goes to, again, the issue of people working remotely and protecting confidential information. I mean, what kinds of things should an employer be thinking about? Devjani, I'll turn to you first in terms of, a lot of companies, banks, for example, I know have had policies that say you can't work from home because we've got access to customer data and limiting the number of people who can work from home. What are companies doing to try to preserve trade secret and confidential information?
Sure. It's really a range depending on the type of work that they do, but it could involve hardware solutions, distributing particular kinds of computers to people so that people are only working on employer-supplied equipment, using VPN or secure channels, requiring passwords for video conferences. But I think one thing we've all experienced throughout this is that people are at home with their families. And so we might be doing a webinar like this, and you will get to know people's spouses, their kids, their dogs, their kids' dogs. And so there's this array of characters that's currently potentially able to access information. And so if it's important to you to protect information, you'll want to think through what communication channels you're using and how you can help employees to maintain a secure environment from a practical standpoint.
Mm-hmm. Okay, and Hiro, do you have anything that you'd care to add to that answer? Is there anything that you've seen in this area and with your Japanese clients?
Well, I think I know what I learned from our Japanese clients about what they are doing in Japan or in the United States is quite similar to what Devjani already described. So, they try to, limit the, laptop computers which they can use to the company issued equipment or, or using VPN or etc. So I do not have, many things to add.
Okay. And Melissa, I'm just wondering if there's anything you'd want to add. In particular, I'm concerned about, and I know a lot of clients have expressed concern about, providing some protection to employers who reopen. Is there some kind of government protection that should be given, some kind of indemnification or immunity? Are you seeing, what are the developments in that area with regard to workplace safety?
Well, I mean, that's complicated. California just passed, for purposes of workers' compensation designation and collection, that a rebuttable presumption that COVID cases, if contracted by a worker, is work-related and it's an occupational illness, which on the one hand is, frightening for employers, but on the other hand, I mean, that's the reason workers' compensation exists, to limit the liability of the employer. So in a
if it's
way,
an occupational illness, doesn't that take it out of, then the employer isn't going to have to reimburse out of their own pocket for the illness. I mean, except for
correct.
the workers' comp premiums. They pay premiums to the state, but it's the state that's going to provide the compensation. That's what you're saying?
Yeah, that's correct. So in a way, while some people find it scary, it's also almost takes it off the employer's plate, and it's saying, of course, it's a rebuttable presumption, so it's going to have to be established, that it was contracted at work, and can be overcome. But at the same time, I also think that in a way it is sort of limiting liability of employers. So it could be a good thing. I mean, we don't yet know how it's going to play out, so we'll see, because California hasn't reopened. But I mean, it may not be a terrible thing. So we'll see.
I mean, it sounds to me as though that, well, let's just end maybe with one more question. And that is, again, sort of the same issue, but maybe turning it around a little. And I would ask this maybe of Devjani. Devjani, what areas do you see where there is a potential for liability for employers coming as we reopen, as we bring people back? What areas, where is there a potential for lawsuits?
I mean, I think, again, there's different ranges of reopening guidelines.
Let me actually jump in real quick with a thought I just had, and that is, Governor Cuomo has this Matilda's law where he says, well, we have to protect our older employees. And so can that lead, how does that potentially lead to liability?
Sure. So, and it's interesting because that law it's a guidance, but not a formally passed law. But there is this idea that people who are older may be at greater risk of complications. And so I think where there's potential liability is if an employer is sort of quickly responding and saying, okay, we're going to have a rule that no one over 60 can come to the workplace, or only people with children will be allowed to work remotely. Anytime you make a decision that's not tied to the individual job, the work that needs to be done, if you want to decide that, for example, all accountants can work remotely because of the nature of their job, that's fine. But if you say, well, only the ones who are over 60 or have school-age children, you can expect that anyone under 60 not having school-age children will file a discrimination claim. I think another big area is, unfortunately, we don't have national guidance. So you may have employees in some of these states that are less protective, who look at the fact that you're taking stronger measures in the states where they're requiring face coverings, distancing, and so on, and say, I'm not working safely, and I know that you're able to provide me a safer work environment because you're doing it for my counterparts elsewhere. I'm blowing the whistle. And again, whistleblower claims can't be waived. So I think that's a big area of liability. And we definitely see that there are law firms that are publishing on this subject and trying to educate people about safety obligations. So those will be big issues.
Yeah, it's an interesting observation because some states, for example, New York, has a very narrow, at least at this point, whistleblower law that only essentially permits whistleblower claims when somebody is complaining about threats to public health or safety. And this may, in fact, I think you're right, maybe perhaps this is going to open the door to expanding claims brought under that law, since there is a pandemic.
Right. And to Melissa's point, different industries, are very used to having safety plans. You maybe didn't have a safety plan based on the fact that you have an open plan office, and suddenly we're confronting a hazard where just having an open plan office might be hazardous, at least for this next period of time. So
yeah, and whose job is it going to be to clean that plexiglass? That's another question I want to know. But look, I think we're at our time limit. I think we're done. I want to thank again Hiro Tsukamoto from Nagashima Ohno. Thank you so much for doing a great job, Melissa Peters and Devjani from Littler. And again, thank you to everybody at the Japan Society, and thank you to all of you for tuning in today. So again, have a good day, stay safe and stay well.